a little bit more on Chapter 6 in negligence. We talked about this duty, breach, cause damages. Now, when we determine negligence in a court proceeding, the judges will typically look at level of fault. How much is each party responsible for the harm that was caused? And in this, we have a couple different manners in which that harm can be determined. Some states, very few, I believe it is just down to 4 states now, they do something called contributory negligence. And what that is the defendant must be 100% at fault in order to have to pay any damages. So if you are partially at fault and you still get injured, you would not receive damages in a state that goes under the contributory negligence plan. Arizona is not one of those states. Arizona goes under and practices under what's called comparative negligence. And what comparative negligence does is they look at percentages of fault. So many times we think when you are, let's say someone runs a red light and hits you, you would sit there and the automatic assumption is to say the person running the red light is 100% at fault. However, if you took off the second that light turned green and you floored your car and you didn't look either way before taking off, you have some fault in the cause of the accident because you didn't follow the proper driving laws either. Now, are you more than 5%, 10% at fault? Probably not, but there is a percentage of fault that you have to incur. And once you incur that level of fault, they will sit there and say, if you are awarded a $100,000 verdict, and the jury says, for all your injuries, you're supposed to get $100,000. The judge is going to look and say, and we'll do this for easy math's sake, you are 10% at fault because you took off right when the light turned green, you didn't look either way before you took off, you had your headphones in, you were texting, whatever it is you were doing. So we're going to assign 10% of the fault to you even though you got hit. And the jury said you should get $100,000. Now, with that comparative negligence, they're going to take $10,000 away from what the defendant owes you, or 10%. And the defendant is only going to have to pay you $90,000, or 90%. And that's how that works. Now, there are a couple other forms of negligence that are unique, that are specific, and they're things that we want to talk about so that you're aware. Now, excuse me, there's something Latin, and what this is called, it's called res ipsa loquitur. And I don't like using Latin that often, but there's no other way to explain this to you other than doing that. And what that means, what it translates to is the facts speak for themselves. So let's say, for example, you went into a hospital because you had diabetes and you had to have your right foot amputated because you weren't properly taking care of yourself. You went into the hospital, got set up for surgery. As you're lying on your back, your right foot is obviously on your right side. The doctor is having a long day. The doctor's a little bit tired. He's looking down at you, and when he looks down at you, he says, "What foot are we supposed to amputate?" Nurse says, "Right foot." He says, "Okay," and he looks on his right and amputates that foot, which happens to be your left foot. Now you wake up, you look down, you kind of look at your right foot, it's still there, you're shocked, you're in pain, you look over to your left leg, there's no foot there. That's negligence that would fall under this category of res ipsa loquitur. The facts speaks for themselves. You don't have to bother proving duty, breach, cause damages. The fact that the doctor amputated the wrong foot goes straight to negligence and right to res ipsa loquitur. It gives you that step up. And that is one of our forms of negligence and laws. Now, another form of negligence and laws that actually protect against negligence is something called the Good Samaritan statute. Let's say you stop to help somebody. They are in a burning car or a car that's about ready to explode, and you pull them out of the car. And while you're pulling them out, you dislocate their shoulder. Was there negligence? Maybe. Or even a better example, let's say someone is choking on a meatball at an Italian restaurant, and you go and you give them the Heimlich maneuver, and as you are freeing their airways of this meatball, you happen to crack a couple of ribs. The Good Samaritan statute protects you against being sued for negligence because you are acting in a manner that would protect the person, to save the life. Now, what is important to understand in this Good Samaritan statute is you have to be the most qualified person to give this type of care. You can't just decide to do it. If someone is choking in a restaurant, and it's all fun and games in movies and TV shows, that are like, they yell, "Is there a doctor in the house?" You have to do that. Because if you are not the best person to perform the Heimlich maneuver, give CPR, do any of these things, if there's a medical trained person who is better at that than you would not be protected under the Good Samaritan statute. But so long as you are the best option, you are protected under the Good Samaritan statute. I'm a dog lover. And you will maybe learn about that about in a couple other videos about me, but there are what are called dangerous domestic animals. Certain breeds of dogs fall into that space. German Shepherds, Boxers, Rottweilers, Great Danes. These animals are, first of all, the pit bulls as well. They're wonderful dogs. Dogs are not bad dogs unless they're trained to be bad dogs. But I digress. If you have one of these dogs, and one of these dogs bites or injures somebody, again, negligence is automatically proven. It's what's called strict liability. They don't have to go through the duty, breach, cause damages. A dangerous dog bit me, the dog owner is liable for all damages. Now, if a Chihuahua bites you, in order to prove negligence by the owner, you have to go through duty, breach, cause damages, because a Chihuahua is not considered a dangerous dog. But if it is labeled a dangerous dog, that liability is automatic. It's what's called strict liability. So, it's a lot in this chapter. Hopefully these videos helped you a little bit, gave you some ideas and thoughts of what it all means. Have a good week and good luck on the exams.